I will get him in a minute. I think I happen to know where he's at, albeit perhaps not in a specific room. Patricia, you want to call over to the sheriff's office and tell
Yes,
them
sir.
we need our defendant back at the seat.
Yes, sir.
You got a little office going in your home, Andrew?
Yes, sir. It's upstairs. And we have a little media room that I can close off and not be bothered by anybody.
You got any children?
Well, I mean, including stepchildren, we have 6.
All right.
So, and there's there he is. Hi, Mr.
He's
Munoz.
back, Judge.
Welcome back.
All right, Mr. Munoz Cruz. All right.
Hello,
Mr. Edelman.
Yes, sir.
That's okay, Mr. Munoz Cruz. We just need you to sit there for a little while. What says Mr. Edelman and Andrew Edelman? It's the Andes.
Well, unfortunately, sir, I haven't had the opportunity to review Torres v. Madrid. However, I have reviewed the case law in Texas from at least Cote v. State through St. George. And if the court accepted the defense's assertion in this case, it would create an interesting paradox. Because under Cote and St. George, a passenger in a vehicle is seized when the vehicle itself is seized. And in fact, that is what gives a passenger in a vehicle standing to challenge the initial legality of the detention itself. So, if there was no reasonable suspicion to stop the vehicle, then any attempted detention of the vehicle in itself was illegal, and Mr. Munoz Cruz would have a good argument. However, since there was reasonable suspicion to detain the vehicle on the basis of the missing front license plate, both of the people in the vehicle, its operator and its passenger, were seized. Now, if Mr. Munoz Cruz had not left the vehicle as alleged when the vehicle came to arrest, ultimately, then he would have reasonable suspicion. Then he would have an argument to challenge the legality of any further detention, because any further detention of him would need to be justified by a separate reasonable suspicion. But that's not what we're talking about here. Mr. Munoz Cruz was a passenger in the vehicle when it was initially detained. He therefore has standing to challenge that detention. That detention was ongoing when the operator of that vehicle then proceeded to try to flee. If it were otherwise, Mr. Munoz Cruz would not have standing to challenge that continued detention. And because that initial detention was reasonable, Mr. Munoz Cruz does not have an argument here that his continued attempted detention was without legal authority. He would have needed to wait at the vehicle rather than running as alleged in the information.
Mr. Freilich.
Judge, I would say that's apples and oranges versus the standing to contest versus the particularized reasonable suspicion and probable cause he would need to have to be detained to begin with. I mean, sure, the driver was driving down the road without a front license plate. The driver was evading the police. The driver was being seized. The driver, when he fled, based on the reasonable suspicion that Deputy Jones articulated having to do with the driver, surely enough, we have particularized reasonable suspicion there. However, as to Mr. Munoz Cruz, there is no particularized reasonable suspicion or probable cause to him. And that's where we draw the fine line there. So if the crime of running from the police is only a crime from running the police when he runs from the police, then we don't have anything that he's running from. Again, this is evading arrest, evading detention. And that needs to be tied back to the probable cause and reasonable suspicion from that detention and that seizure. And that's where we're drawing a fine line. Whether or not he is standing to contest the original stop is not the issue. We don't have a problem with the original stop of the vehicle and the driver therein. It is a license plate violation tying directly back to the driver. There's no evidence that Mr. Munoz Cruz owned the vehicle, operating the motor vehicle, or had any duty to have a front license plate on that vehicle. So we have nothing with Mr. Munoz Cruz to detain or arrest him at that point. So when he takes off on foot, allegedly, at that point, we don't have anything for the arrest or detention for him to be evading from, particularized to Mr. Munoz Cruz specifically. And that's the nexus of argument. Whether or not he's standing.
Andrew Freilich, your basis, your legal site is Torres versus Miranda?
Torres versus Madrid.
Madrid.
Country in Spain. Mm-hmm.
Also a hamburger joint, Madrid. And you don't have the actual site?
For Torres versus Madrid, it's a Supreme Court case from March of 2021. It is a slip opinion. It was decided March 25th of 2021. So it doesn't have a specific site. It's number 19-292. And I attached that in the chat so that everyone have a copy of it.
All right. And Mr. Edelman, you're saying Texas law says if a vehicle is detained, so is the passenger, any person in the vehicle at that point. And what is the site on that?
152 Southwest 3rd, 54. That's Cothey State. And 237.
Say again. So the name?
I don't know if I'm pronouncing it correctly, sir, so I'm going to spell it. K-O-T-H-E versus State.
K-O-P?
No, sir. K-O-T as in tree.
K-O-T?
H-E.
H like hotel?
Yes, sir. E like echo.
Cothey or Coth?
Something like that, sir. And then St. George v. State 237 Southwest 3rd, 720.
Are these criminal appeals or
Yes, sir.
appeals?
Both cases decided by the Court of Criminal Appeals of Texas. Neither overruled.
All right. Do you have any other? I understood you to say there's no more witnesses, Mr. Edelman
That is correct, sir.
and Mr. Freilich. Do you have any witnesses?
I need to confer with my client briefly to see if he is going to testify at this time.
All right, Patricia. I'll ask you to put Mr. Freilich and Mr. Munoz Cruz in breakout, but I have a couple of questions for the state. The witness, in a refreshing bit of honesty, said that the defendant had not violated any laws. He didn't indicate anything about a detainer or that he considered the defendant under detention. The cases in our Texas Criminal Code, O'Connor's, there's a couple of cases, including Rhodes versus State, that pretty well makes the idea of an arrest circumstances a favorite expression of others' totality of circumstances. Mr. Freilich raises an interesting point in that, and specifically where the witness says, hey, he hadn't done nothing. There's nothing wrong with him. He didn't do any, he did not commit any kind of violation of the law. His words, violations. So the citations you have are interesting because they're saying the vehicle's detained everybody in it. You can have 10 people in there. One of them intended to be arrested and all the other 9 are under detention also for whatever reason. Is that essentially what's being said by those 2 cases?
Yes, sir. And Your Honor, if a passenger of a vehicle were to have standing to challenge the legality of a detention, then they would need to be detained as much as the operator of the vehicle.
Perhaps. That makes sense. On the other side of it is, there's all kinds of reasons. There's all kinds of reasons and ways to challenge detentions or arrests based on the facts, not necessarily that there is in fact a detention that has occurred. Interesting situation. All right. Anything else you want to add, Mr. Freilich? I know you're gonna meet with your client. I understand that.
Right. I mean, I don't know. I know that in a lot of our practice seminars, they tell you to push for a ruling before we continue. Are you going to hold off on that ruling and consider it? Or
I am. I'm not going to rule right this second.
Okay. So then it would be up to us to present evidence at this time.
That's fine. But did you want to meet with your client first
To decide if it's going to the Fifth Amendment? Yes, Your Honor, I did. I just wanted to hear the arguments. I know you're talking to Mr. Edelman. I want to make sure that we're on I didn't miss anything there, but when I went to a breakout room. So yeah, I'm going to join the breakout room with Mr. Munoz Cruz now, and then we'll come back.
All righty. Patricia, if you will accommodate them.
Breakout room 3.
Your Honor, what is the citation on that case you mentioned, Rhodes v. State?
The Torres versus Madrid.
No, Rhodes v. State. You
Oh,
mentioned it.
that's this one here. It's 945 Southwest Second, 115 at 117. It has that portion of the thing here. It appears to be a Texas Criminal Appeals.
Nine 945. I typed in 954.
945 Southwest Second, 115.
I see it, sir. Did you find Torres versus Madrid, Mr. Edelman? Yes, sir. I have it. I just haven't had an opportunity to read the entire thing.
Looks like you're back, Mr. Freilich.
It is, Your Honor. We the defense will not call any witnesses. The defense rests.
All right. Mr. Freilich, would you please deliver to me the two cases that you cited, or rather the case, Torres versus Madrid? The state has a copy, the court does not. And then Mr. Edelman, if you will deliver to me copies by computer is fine with me, to john@longoria.com.
Judge,
Yes,
if
sir.
you see the chat on your right, there's a chat function on your right, which I delivered Torres versus Madrid. It's a P. Download it from there. That might be the easiest way to do it.
There you are, chat. All right. Torres v. Madrid. Download. You're going to have to help me out some here because I got a whole series of stuff. Save as. No. Kayleen, are you able to download this stuff? The Torres v. Madrid case?
No, sir, not from your email.
I didn't. Okay.
Your Honor,
Yes.
I will send a copy of it to you via email.
All right. And then be kind enough to send me yours.
I did, sir.
All right.
You should see them in your email inbox.
I will read them and then I'll render a ruling. I find it a little bit unique. You know, it sounds like the Court of Criminal Appeals is saying, hey, if you got a carload of 4, 5, 6 people and there's a legitimate lights are off on the license plate, no backlight or stoplight or whatever, and the car stops after a chase, then everybody in the car is in detention at that point. Maybe so. My problem here is that, as I said earlier, you have a deputy says, hey, he committed no violation, period. He gave no indication of reasonable suspicion, but what you're saying, Mr. Edelman, is everyone in the car is subject to detention and everything that includes, including he couldn't, he ran off, but he allegedly ran off, but he also could have walked off, just walk away. And you're saying, the law says you got to stay there with the car, no matter how innocent you may have been or not.
And
We'll see.
if I may, Your Honor, you mentioned a case called Rhodes v. State. I've had an opportunity to read
Yeah,
Rhodes v. State, and
it's a car chase.
It seems to assert the same principle. And if I may, quoting Rhodes v. State, the Fourth Amendment does not forbid all searches and seizures, but unreasonable searches and seizures. Continuing, the Supreme Court has held police officers may stop and briefly detain persons reasonably suspected of criminal activity, even if probable cause to arrest is not then present. This court has held that passengers in an automobile are subject to temporary investigative detentions in the same manners as pedestrians. The Ninth Circuit Court of Appeals recently held that police officers may ask passengers to exit a vehicle after the officers have stopped the car in order to protect the officers, citing Ruvalcaba v. Los Angeles. The court, in effect, found asking the passengers to exit the vehicle was a minimal intrusion on their privacy interests, and this intrusion was outweighed by the officers' reasonable concern for their safety. Thus, officers may use such force as is reasonably necessary to effect the goal of the stop: investigation, maintenance of the status quo, or officer safety. We have held that we will follow the federal Terry standard with respect to temporary investigative stops and have found no reason to employ a more stringent standard under the Texas Constitution with respect to such stops. The court concludes. The court noted, referring to the Supreme Court, the court noted further that passengers are already stopped and extending the rule of Pennsylvania v. Mims. In quotations, an officer may, as a matter of course, order the driver of a lawfully stopped vehicle to exit his vehicle, close parentheses, to cover passengers is not an unreasonable violation of their rights under the Fourth Amendment. So
All of that I don't disagree with. There is a nuance here that worries me at this point, and that is that the officer at no time indicated that he detained or had intention of detaining the passenger. In fact, he's pretty clear saying, hey, he hadn't done anything. He made no violations. There's a little bit of a distinction there because he did not assert a detention. And what I'm hearing is a car stopped, everyone inside of it is, regardless of the reason or not, or regardless of whether an individual is identified as not in violation of any laws, that takes out the reasonable suspicion element and leaves it only a car stopped, everyone and everything in it is subject to, is considered detained. Not just subject to detention, because he could, if the kid had, if the defendant had stayed in the car and he says, okay, I need to ask you some questions, I need to talk to you because you're under detention, even if he just thought it, that's a little bit of a nuance that I'm concerned with. And I understand very clearly what you're saying.
In addition, Judge, can I point out one additional thing? In the case that just came out that I cited, again, it's if he had gotten Mr. Uziel Munoz Cruz out of the vehicle, asked him to step out of the vehicle, hey, I'm just detaining you for the brief purpose because that jerk over there is running from the police, that jerk over the driver, and done that and detained him, that would be different as well, because my client was never actually seized for Fourth Amendment purpose. The Supreme Court case. Let me back up, Judge. Hang on a second. Let me try this. Let me try something else.
Yeah, you did okay till you said it seemed, or you.
So let me start and see if I can. Am I being clear at this point?
At this point, you are.
Okay. So the Supreme Court case that I cited, Judge, places specific purposes on when someone is detained for Fourth Amendment purposes, when someone is seized for Fourth Amendment purposes, and goes back into a deep discussion of the common law as to when someone is seized or detained. And what that means is, because there's no testimony from Deputy Jones that Uziel Munoz Cruz was actually detained, was actually under investigation, was actually seized for Fourth Amendment purposes. If he had said, hey, stop passenger right there, that would be different. At that point, he would be seized, and continuing to evade at that point in time would be evading illegal detention, would be evading detention, would be evading arrest, would be evading the Terry stop. But because he was never seized, he can't actually be evading detention or seizure. Like you said, Judge, even if he had thought it, but he didn't, there's no evidence that he had a reasonable suspicion or probable cause to detain him, but there's also no evidence that he was seized for Fourth Amendment purposes, according to the most recent Supreme Court opinion. Therefore,
that's what I need to see and read.
Right. And that's the second part of the argument. The first part is he didn't have any reason to seize or detain him. But even if he did have the probable cause or reasonable suspicion, as Mr. Edelman alleges, he still wasn't seized or detained for Fourth Amendment purposes. And if that part had been included, that would mean the evading case would fall under that purview of being detained or seized. If he had issued a command, theoretically under the case law, if he had shot a bullet at Mr. Munoz Cruz, if he had made some overture of detention to allow Mr. Munoz Cruz to know he was being seized or detained, that would be the evading that would come afterwards. But that's the second part of the argument. So there's two distinct arguments we're making, Judge. I want to make sure those are clear in my argument. First is no probable cause or reasonable suspicion to detain. Second one is he is not seized or detained for Fourth Amendment purposes. Therefore, there can be no evading case.
I hear you. It's an interesting situation. Both appear to be relatively good law as far as I'm concerned. Anytime, the ultimate issue to me is a detention automatic when you detain or when you make when you stop a vehicle, no matter how many people are in it. You know, I have in mind the circus thing where you have 10, 12 people in a little bitty car. It stops and everybody runs in different directions. Well, you know, does that create a danger for police officers? It might. What are the circumstances? And here we have a very clear circumstance where was he automatically detained because the vehicle was stopped? We're going to see how fine a line I can find in the case law and see if there's a distinction. Mr. Freilich clearly says that the Torres versus Madrid case says no. And Mr. Edelman, you say that the Texas Court of Criminal Appeals says very clearly, oh yeah, you stop a vehicle, everyone inside of it is under detention under the law. I'll read them. I've just got 3 cases to read. So as soon as I do, hopefully we'll do it tonight. Then I'll give you a ruling right away.
Yes, sir.
All righty.
And Judge, I think my client does need to be present when you make a ruling. I don't know if there's any additional evidence to consider. I believe we've already rested and closed.
All right. Well, let's do it. Mr. Edelman, does the state rest?
State rest.
Mr. Freilich, does defense rest?
Rest and close, Judge.
Mr. Edelman, state closes.
State closes.
All right. Then you've heard what I'm going to do. I'm going to read these 3 cases, and I'll try to see what's the best ruling I can give you that's fair and that's also reality in our community. All right, gentlemen, unless there's something you want to state besides what's been said, Deputy Jones.
Yes, sir.
We appreciate you being here. I hope that you and your loved ones are safe, and you stay safe. Be careful, huh?
Thank you, Your Honor. Thank you for all you did.
I just gotta say this. I don't know why your mom and daddy named you Ebony.
Your Honor, I was, yeah, Your Honor, I'm a product of the 70s, and in the 70s, there was this magazine called Ebony, and my grandmother saw that magazine, and that's how my name came about.
No kidding. Yeah, I do
Yeah.
remember the magazine. Absolutely.
Yes, sir.